Hello, welcome to our webinar. Today we are going to discuss the mistakes you can avoid if you want to protect your assets from the cost of long-term care. Do you know that Connecticut nursing homes can be $600 per day? That's $18,000 a month. Most people cannot afford this unexpected expense. We are going to talk about ways that you can protect your assets from this expense. Allow me to switch over to our PowerPoint and we will go over this item by item. What you will learn today is how does long-term care and Medicaid work? What are the biggest mistakes that people make that lead to nursing home poverty? And how to protect your assets from the exorbitant cost of a nursing home. To thank you for showing up and being committed to achieving these goals, I'm going to also give you something special to show my appreciation. Because of the COVID-19 crisis, we feel that everyone over the age of 18 should have a healthcare representative named. Therefore, we're offering a free advance directive, which includes the appointment of a healthcare representative and a living will. This important estate planning document usually costs $250. So stick around to the end and you'll find out how to get that. I have been practicing law in Connecticut for over 30 years and my law firm has been around since 1945. So we are in our 75th year. Our firm specializes in estate planning and elder law, and we have a great deal of experience in these areas. Please feel free to ask questions as we move forward, and I will answer them at the end of this webinar. Let's talk a little bit about how long-term care and Medicaid work. I'll give you an example of clients of ours who unfortunately did not do any planning. They had a basic will, but had done no advanced planning for the cost of long-term care. Frank had a stroke and needed to be placed in a long-term care facility. His wife was facing a spend down of assets. They had about $300,000 in retirement assets, $200,000 in invested assets in their home. The home was exempt as long as Mary was living in it, but of the $500,000 of other assets, they were forced to spend those down to $125,000. That meant before Frank can get Medicaid benefits and have the state pay for the cost of his long-term care, they had to spend $375,000 of their $500,000 of savings. This is devastating to anybody. The cost of nursing home care or in-home care can be very, very expensive. If you don't have long-term care to cover this or don't feel confident in purchasing long-term care at this time because of the expense or the rising premiums, then you need to consider planning. People don't think that this is going to happen to them until it does. Common triggers that can create a situation where you need long-term care include falls, dementia, a stroke, as happened to our client Frank, and other debilitating diseases. If this happens and you need care, what are your options? One home care option is the Connecticut Home Care Program for elders, and that can put care into your house. It does have certain income and asset requirements, and there are state-funded and federally funded programs. Medicaid was created for those people who were impoverished. So to avail yourself to the benefits of Medicaid, you basically have to impoverish yourself. There's some planning ways that we can do that in advance. But if you don't plan, then you're forced to impoverish yourself at the 11th hour, and it's done in what we call crisis planning. We're going to talk a little bit about what you're allowed to keep. If we are in a situation where it's a single individual, then in Connecticut, unfortunately, all you can keep is $1,600 of assets, a pre-needs funeral account, and that's about it. Everything else has to be spent down. In a husband and wife situation, there are certain exempt assets. So your home with a certain amount of equity is always going to be exempt as long as one of the spouses is living in it. And the spouse can keep a car, pre-needs funeral accounts, and up to $125,000 of other assets. Everything else has to be spent down in one form or another. Spend downs can be used for pre-needs funeral accounts, a new car, improvements to the house, legal fees, and annuities. The annuities are a very specialized practice, and that would be covered in more detail in another webinar. Let's talk about some of the mistakes that people make. And Frank and Mary, as I mentioned, had a very basic estate plan. But let's talk about another set of clients, John and Colleen. They had done a much more elaborate estate plan about 10 years before they came to see us. They had set up what's known as a revocable or a living trust. They thought that that document gave them Medicaid asset protection. Unfortunately, they were wrong. Because the trust is revocable, they have complete control over the assets in that trust, and it does not give asset protection. We use a lot of revocable trusts and living trusts in this office, but we always differentiate to our client that a revocable living trust does not offer asset protection. In John and Colleen's case, they did have certain exempt assets, but one of the assets that Colleen owned that was not exempt was the beach house that she inherited from her parents. Because it was a non-exempt asset, she was obligated to sell that asset and use the proceeds for John's care before John would be eligible for Medicaid. Another common mistake that people make is allowing the nursing home to prepare the application for them. In the state of Connecticut, a nursing home has a private pay rate, and they have a state-approved Medicaid rate. The Medicaid rate is usually about 50% or less than their private pay rate. So therefore, if the private pay rate was $18,000 a month, the Medicaid rate, the amount the state would pay the nursing home, is going to be less than $8,000 per month. Therefore, you can assume that the nursing home is not in a real hurry to offer you ways of protecting your assets. They want you to be private pay as long as possible. It almost doubles the revenue they're going to collect from you as opposed to what they would collect once the Medicaid application is approved. We don't work for the nursing home. We don't work for the state of Connecticut. We work for you, and we do our best to get your application approved as quickly as possible so that the state is picking up the bill rather than you or your family. We also use all of the techniques that are available to protect whatever assets we can for you, your spouse, and your family. Another problem we see is the attorney that says, yeah, I can do that. They might have done your real estate closing. They might have handled a drunk driving case for one of your children, and they're the attorney that you know, and you call them and say, yeah, we can help you with that. If they're not versed in all of the intricacies of Medicaid and Medicaid planning, you don't want them. to dabble in it at your expense. Many of the referrals this firm gets is from other attorneys that realize that this is well beyond their area of expertise, and they send their clients to us because they understand that we know the ins and outs of Medicaid planning. So now let's talk about how to protect your assets from the exorbitant cost of a nursing home. Let's give another example. Clients of ours who came to see us, and they came to see us when Sally was diagnosed with Parkinson's disease. It's a very progressive disease, and it takes away your abilities over time. It gave us the ability to do some planning. Roy and Sally were able to transfer certain assets out of their names and into a trust. And we'll talk about that a little bit more. And by doing so, they started what's known as the 5-year clock for Medicaid. The 5-year clock is the time period at which you must season a gift before the gifted asset is protected. Thankfully, Roy and Sally had time, did some advanced planning, and about 7 years after they originally came to see us, they were in a position where Sally needed extensive home care, and they were able to apply for the Connecticut Home Care Program for Elders and make themselves almost immediately available because they had gifted assets earlier than 5 years, protected those assets, and did not have a significant spend down that they had to comply with before Sally would be eligible for care. A little bit of my philosophy, our firm's philosophy, is that we don't look at our representation of our clients as being a transaction. We want to create a relationship with our clients, and we want them to feel free to ask us questions at any time. We may do something for you in the year 2020, and if you have a question the following year or several years later, please feel free to call us. We would rather have you ask a question than pay the price long-term for a mistake you might make. Let's talk a little bit about estate planning basics. What is a will? A will is a document that speaks after your death and names your executor, names guardians of minor children, and disposes of your assets. What is a trust? Well, a trust is an agreement between you and another person, a trustee, and it states what will happen with your assets upon your death. There are revocable trusts and there are irrevocable trusts. Revocable trusts are often used to avoid probate and avoid delay and expense in the administration of an estate. Irrevocable trusts are often used in our firm for Medicaid planning. There are protections with a trust, and those can be protections for you and those who inherit from you. We like to set up asset protection features in our trusts that protect your assets during your life and protect the inheritance that you leave to your children or other beneficiaries. There's a study out there that says that left to their own devices, most people will spend their inheritance between 18 and 26 months from the receipt. We like to set up estate plans that avoid that and set up asset protection trusts for multiple generations. We discussed the 5-year look-back period, but it is important that you keep in touch with us during the entire process, during the 5-year process, after making gifts and thereafter, so that we can keep up to date with your needs. You need to decide what your story is going to be and what your legacy is going to be for your children or your beneficiaries. It's important that you consider planning to avoid the catastrophic cost of long-term care. And we think that using a trust is one of the best ways of doing so. It allows you to control what happens with your assets during your life, but also still protect them from the cost of long-term care. We do have a couple of questions that have come in, so let me just take a look at those. Let's see, Tom asked the question, this sounds complicated, how long does this take? The process is somewhat complex, but the complexity is for us to deal with. We try to simplify it for you. We like to move this forward as quickly as possible and usually can get everything done within a couple of meetings that can take anywhere between 3 to 6 weeks from beginning to end. The important thing is getting the 5-year clock started so that we can then track when your assets become protected. The important thing is that we work with you to identify the assets that can go into your trust. We also work with your accountant, your financial advisor, so there's a team approach to this. Let's see, Sarah has a question. I run marathons and eat vegan every day. I'm not worried about going into a nursing home. What documents are right for me? Well, I would say that no one should assume they're immune from a nursing home. My mother was a very active person. She played tennis well into her late 60s. And when she turned about 70, she was diagnosed with Lou Gehrig's disease, ALS. And that had a devastating effect. The next 5 years of her life were very difficult until she passed away 6 months shy of her 75th birthday. She might have been like Sarah and said, I'm healthy, I don't need to worry about a nursing home. But in the end, she needed almost 24/7 care until she finally succumbed to the illness. So I would say, Sarah, then you should be considering some sort of planning to avoid long-term care. At least you need to have some basic estate planning, which includes a will, a power of attorney, advanced directives, which we're giving away free today, and possibly a revocable or irrevocable trust. Mike has a question. Can I change the terms of the trust if my family circumstances change? And the answer is yes. And that is why we like to use a trust rather than just give away assets to children. You can keep certain controls over your assets when you place them into the irrevocable trust that we prepare. If necessary, you can change the trustees. Normally, we name the children as trustees or a child, but if something happens to that child, we build in the ability for you to remove and replace the trustee with the assistance of what's known as a trust protector. If circumstances change, if your child is going through a divorce, if your child comes down with an illness, gets diagnosed with multiple sclerosis at 32 years of age, and you need to change the type of distribution to your beneficiaries, you retain some controls over the trust so that you can do so. We like to build as much flexibility in these trusts as absolutely possible without affecting the Medicaid protection that is the bedrock of this type of planning. Well, I thank you for your time today. We're coming to the end. As promised, we have a special offer for you, And all you need to do is click on below and let us get some basic information, and we'll be able to prepare your advance directives and the appointment of your healthcare representative. Again, a $250 value, and we're doing that for free today because you thought it wise to listen to this presentation and get this information from this webinar. So if you've made it this far, something is resonating with you, and we're here to help you. I want to offer you a 1-hour session with my team to help you get your assets protected. The truth is that everyone has a unique situation with their assets, their family, and their needs, and it takes a certain amount of expertise to help make sure that you have the right legal documents in place for you and your family. There's no substitute for sitting down with a professional to get this set up, but the plus side is once you get it set up, you can have the peace of mind of knowing that you and your family will be taken care of. If you walked into my office today, you would be charged $450 for a consultation to sit down for an hour to an hour and a half and assess your situation. We charge normally a fee of over $300 per hour, and this session usually lasts for 90 minutes. But since you've taken the time to listen to this webinar and now have some basic understanding of what we can do for you, we're offering a special offer to you. Please click on the link below, and a member of our staff will set up an initial appointment with you free of charge. Now remember, getting the documents in place will cost money. We'll talk about the cost because everyone's situation is different. But by the end of our initial consultation, I will be able to give you an idea of what I think will work best for you and your family and give you a cost for that service. Click the link below and we can set up an appointment for you. We have spots available that we reserve for members who have listened to this webinar, and we want you to take advantage of that. Again, I want to thank you for taking your time today. I appreciate you investing your time and energy into this webinar, and it shows how committed you are to protect your assets for each other and for your family. It's really important these days to think ahead and make sure that you've planned for unexpected illnesses. Again, we have a bonus for you. Please call the number at the bottom of the screen, mention the webinar, and we are happy to set up your advance directives and appointment of a healthcare representative for you. I look forward to seeing you in person, and thank you again for taking your time today. You have a great day.